Good day. It is a distinct privilege for me to participate in the OECD's 2020 Global Forum on Competition. With thanks to the OECD, the participants and panelists at the forthcoming roundtable on remedies and commitments in abuse of dominance cases, I am pleased to share this brief presentation on abuse of dominance, remedies, commitment decisions, and related institutional arrangements under the Philippine Competition Act. In this presentation, I hope to introduce you to the abuse of dominance provisions of our Philippine Competition Act, the approach under the law with respect to remedies, the commitment decisions that have been recently promulgated by our Philippine Competition Commission in compulsory notification cases for purposes of exploring what we can learn from these commitment decisions that may apply to the development, configuration, and application of remedies in abuse of dominance cases. Then I will briefly present the Urban-Deca Commission decision, the first decision of the Philippine Competition Commission involving abuse of dominance, which was taken on the basis of a joint settlement submission between the entities and the Philippine Competition Commission's Competition Enforcement Office. Let's begin our discussion with abuse of dominance under the Philippine Competition Act. Now, in order to offer a perspective or context for appreciating the challenges that attend enforcement in the area of abuse of dominance, I will present the scope of the Philippine Competition Act, as well as briefly discuss that abuse of dominance is one of the three pillars that have been adopted under the Philippine Competition Act, which means that the Philippine Competition Commission is concerned not just with enforcing in the case of abuse of dominance, but also in anti-competitive conduct and anti-competitive mergers and acquisitions. So the Philippine Competition Act is enforceable against any person or entity engaged in trade, industry, and commerce in the Republic of the Philippines. It is also applicable to international trade, having direct, substantial, and reasonably foreseeable effects in trade, industry, or commerce in the Republic of the Philippines. This means that the scope of our law includes those that result from acts that are done outside of the Republic of the Philippines. This scope, of course, poses a challenge in terms of designing remedies where entities involved or acts involved are outside of the country. Our law also adopted the three pillars of enforcement or the three pillars of competition. When our law was passed in 2015, over 119 jurisdictions already had in place competition legislation or antitrust legislation. Therefore, our legislators had a number of models to choose from. And in passing the Philippine Competition Act, they decided on adopting the three pillars of competition. So there is, under our law, and therefore there is enforcement in the areas where there are prohibited forms of conduct. So under our law, anti-competitive agreements are prohibited under Chapter 3, Section 14. Abuses of dominant position are also prohibited under Chapter 3, Section 15. And under Chapter 4, Section 16 to 23, our jurisdiction conducts a review of mergers and acquisitions across three modalities: compulsory notification, a motu proprio, or a review of mergers and acquisitions upon the initiative of the Philippine Competition Commission, and voluntary notification. So all of these activities are undertaken by our central or primary competition agency, the Philippine Competition Commission, which of course means that they have to be judicious in terms of allocating resources, but also committed to developing the technical capability across these three areas of enforcement. So let's turn specifically to abuse of dominant position. As you can see here, our jurisdiction has adopted or recognizes not just individual abuse of dominance, but collective dominance. It is prohibited in our jurisdiction for one or more entities to abuse their dominant position by engaging in conduct that would substantially prevent, restrict, or lessen competition. Our law enumerates specific forms of conduct that may fall afoul of Section 15. But our Philippine Competition Commission has taken the view that this list, while long, is not exhaustive, and therefore analogous situations may also be considered as prohibited under Section 15. Our law provides for a rebuttable presumption of market dominant position with a market share of at least 50%. With this presumption, there is some, this presumption aids the competitive analysis in abuse of dominance cases. However, the PCC is authorized under our law to adjust this threshold or to determine the applicable threshold to particular markets, sectors, or industries. Our law also recognizes exemptions, meaning to say the acquiring, maintaining, and increasing of market share through legitimate means would not be considered as prohibited. And this may be done through possession of superior skills, rendering superior service, producing or distributing quality products, having business acumen, and possession of legal rights such as intellectual property rights. Our law also provides for specific steps in the analytical framework, and in consideration of the provisions of the PCA on this point, our Supreme Court has, in a recent case, set out the evidentiary requirement in abuse of dominance analysis. So according to our Supreme Court, the evidentiary requirement in abuse of dominance analysis involves the determination of the relevant market, a determination that the entity has achieved a dominant position in that relevant market, and that the entity commits acts constituting abuse of dominance. And this must be done under the facts-based criteria in Section 27 of the Philippine Competition Act. So the scope of the Philippine Competition Act, the specificity and the exactness, the technical analysis that's involved in relation to abuse of dominance cases make enforcement in this particular area challenging. And this, of course, includes the development or the configuration of remedies in the cases which may be brought before the Philippine Competition Commission. It is worth noting at this point that we are awaiting further guidelines or further guidance from the Philippine Competition Commission in two areas. One, with respect to what stakeholders, particularly those in business, should watch out for in order to avoid committing any of the forms of conduct that would be considered an abuse of a dominant position as provided in the Philippine Competition Act. And we're also awaiting guidance in terms of how remedies may be shaped so as to inform also not just the conduct of stakeholders, but how markets are currently structured. These two guidelines are also significant because the administrative fines are quite high under our Philippine Competition Act. In fact, these amounts, I believe, remain unprecedented, meaning to say across other regulatory statutes, these fines remain among the highest, if not the highest imposable. So let's turn very briefly to remedies. So while we are awaiting guidelines on how to craft remedies, not only for abuse of dominance, but also for anti-competitive agreement cases. Our law has offered some direction in terms of the imposition and implementation of remedies, as well as containing very specific provisions on non-adversarial remedies, or those processes that are available to parties in order to ensure that they continue to be compliant with the Philippine Competition Act. Okay. Before we discuss remedies under the Philippine Competition Act, it's also useful to understand that these remedies are within the authority of the Philippine Competition Commission to impose. Our Philippine Competition Commission is not just an administrative body, it is a quasi-judicial body, meaning to say it may conduct investigation of abuse of dominance cases, as well as adjudicate these cases. And in the course of both investigating and adjudicating, as we will see later on, it may already consider the application of remedies. So under the Philippine Competition Act, it is the PCC that is authorized to stop or redress the abuse of dominance by applying remedies under such reasonable parameters under pertinent rules and regulations that the PCC itself may also promulgate. The PCA further provides in relation to remedies that structural remedies should only be imposed where there is no equally effective behavioral remedy, or where any equally effective behavioral remedy would be burdensome than the structural remedy. The PCA goes further by giving some examples of remedies that may be applied by the Philippine Competition Commission. The PCA says that these examples are issuances of injunctions, requirement of divestment, and disgorgement of excess profits. The Philippine Competition Act also offers non-adversarial remedies. These remedies are available to encourage voluntary compliance with the PCA and other competition laws. Because they are intended to foster compliance and therefore be preventive in a sense, these are available before the institution of administrative, civil, or criminal action. Among the forms of non-adversarial remedies that are available under the PCA are a binding ruling, a show cause order, or a consent order, which may be initiated at the instance of the entity who offers a proposal for a consent order. Now, sector regulators have a role not only in the adjudication of competition cases before the Philippine Competition Commission, they may effectively also have a role in the crafting of remedies. So while the PCC has original jurisdiction over the enforcement of the Philippine Competition Act and its IRR, its jurisdiction is also described as primary rather than exclusive. This is a recognition that there are certain agencies or regulators that may have retained a competition mandate under their own enabling legislation. So while the PCC has the power to conduct inquiry, to investigate, and hear and decide cases involving the violation of the Philippine Competition Act and other existing laws, concerned regulators must be consulted and afforded a reasonable opportunity to submit their own opinion and recommendation on the matter before the PCC makes a decision on any case. In addition, our law specifically says that PCC and sector regulators shall work together to prevent abuse of market power by dominant players within the relevant market or sectors. So this opens an opportunity for exploring the experience of sector regulators, in particular those with a competition mandate, in terms of having applied or having considered remedies in relation to competition issues arising within the regulated sector. Let me turn for a few minutes to commitment decisions. So as I mentioned earlier, in terms of remedies, our Philippine Competition Act, the implementing rules and regulations promulgated by the Philippine Competition Commission, other issuances of the Philippine Competition Commission, including the rules of procedure in the enforcement of the Philippine Competition Act, offer some guidance in terms of what remedies are available, particularly between behavioral and structural remedies, how remedies may be selected, at least between behavioral and structural remedies, and when remedies may be available, particularly through the non-adversarial procedures that are provided in the Philippine Competition Act. Now, what's interesting is while at the moment we have only one case in abuse of dominance where remedies were not imposed, okay, but the abuse of dominance addressed by way of a joint settlement agreement, the Philippine Competition Commission has had experience in terms of receiving voluntary undertakings, assessing these voluntary commitments, and promulgating commitment decisions in compulsory notification cases. So I mentioned this experience here so that we can see if the experience offers learnings in terms of remedies in abuse of dominance cases. So under the rules of merger procedures, voluntary commitments may be submitted by the notifying parties at any time during the compulsory review process and before the PCC has rendered a decision. At any stage of the phase 1 or 2 review, merger parties may propose commitments that will remedy, mitigate, or prevent the competition concerns identified by the PCC as arising from the merger. However, although we now have a few 4 to 5 commitment decisions, at the time the early commitment decisions were rendered, the PCC did not have detailed or specific guidelines on commitments or remedies apart from the merger review guidelines, the rules on merger procedure, and the Commission's commitment decisions in a few cases. So the experience in the more recent Commission decisions have grown from the earlier decisions that the Philippine Competition Commission had taken. And what we can see in these commitment decisions is that the PCC has previously accepted the following types of voluntary undertakings or commitments. The PCC has accepted a pricing commitment or a pricing policy commitment, a service quality or level commitment, pricing and service commitments, as well as commitments on maintaining certain contracting terms based on fair, reasonable, and non-discriminatory terms, undertaking to provide data and reports, and the PCC has been able to secure voluntarily from parties a monitoring commitment whereby parties not only agree to submit reports, but they also agree to work with a third-party monitor whose services are procured at the cost of the merging parties. And these commitments have been received and accepted by the Philippine Competition Commission over a fairly lengthy commitment period of 5 to 10 years. So in one instance, the total commitment period is 10 years. So it's worth reflecting on one, monitoring the success of these commitments, meaning the ability and the commitment of the parties to their fulfillment, and two, examining the reasons for why these commitments appear to be behavioral in nature rather than structural. Okay, and in that respect, I offer three reasons. One, because again, by the language of our Philippine Competition Act, although it is quite specific to cases other than in the review of mergers and acquisitions, there appears to be a preference for prioritizing behavioral remedies over structural remedies. Number two, as we mentioned earlier, we are awaiting guidelines not only on, for example, abuse of dominance cases, but we are also awaiting specific guidelines on making voluntary offer of undertakings or commitments, how it will be assessed, and other policies that may be adopted in relation to receiving commitments, voluntary commitments or undertakings from the parties. In addition, in 2020, it would appear that the Philippine Competition Commission opened a tender for experts to advise the Philippine Competition Commission in relation to the negotiation, implementation, and monitoring of voluntary commitments, as well as in preparing a divestiture manual and offering a training in relation to divestiture. So there appears to be, therefore, a need for continued capacity building on the part of the agency. So as I mentioned earlier, in abuse of dominance, we do have one decided case in which remedies appear to have been implemented, but they were not imposed, but rather they are based on a joint settlement agreement received by the Commission from the entities involved and the Philippine Competition Commission's Competition Enforcement Office. The CEO in this case determined that one of the entities, Urban Deca, abused its dominant position in the provision of property management services by preventing internet service providers other than FTTH from providing fixed line services to the residents of a condominium development, and considered a related company, 8990 Holdings, solidarily liable. Now, these two companies admitted their anti-competitive conduct, and in this decision, the scope was expanded to other condominium development projects. The companies and the CEO submitted a joint motion for settlement. This happened after full administrative investigation had been concluded by the CEO by submitting a statement of objections to the Philippine Competition Commission, and before the Commission could adjudicate this particular case. And the joint motion for settlement sets out the statement of the conduct and the admission of the entities, a commitment to cease the prohibited conduct, a statement on the penalty involved, and monitoring and reportorial requirements. Although, as I mentioned earlier, the term commitment appears in the merger rules, the Commission decision in Urban Deca actually states that the Commission found the commitments, the terms and conditions in the joint motion for settlement to be sufficient to address the harms arising from the admitted conduct. So that gives us an indication in terms of, at this point, with commitment decisions having been previously promulgated by the PCC, that might have informed how the Commission approached concluding this particular case on the basis of the joint motion for settlement. I'd like to add that this decision also cites the OECD Policy Roundtables, Remedies, and Sanctions in Abuse of Dominance case from 2006, as well as some decisions of the EU Court of Justice. I hope that with that brief presentation and taking that information together, let me share some concluding thoughts. A reflection on the information that I have just shared indicates for me the need for internal guidelines, such as a divestiture manual and a guidance for stakeholders on understanding what remedies are available, the imposition of remedies as opposed to making a voluntary offer of undertakings and commitments. It is also important to closely monitor the effect in a future case of imposing remedies following litigation and adjudication, and what guidance or the quality of the guidance that this may offer as compared to decisions based on settlement and voluntary commitments, notwithstanding the admission that entities make. It's worth noting, for example, that in Urban Deca, despite the admission made by Urban Deca and 8990 Holdings, which is a listed company, the value of the company actually increased following the release of the information that a settlement had been reached in relation to the case. It's also important to examine the applicable remedies for developing economies and the specific sector or market affected. This will require revisiting our Philippine Competition Act provisions on behavioral and structural remedies. Is there a direction elsewhere in the world to pursue structural remedies? And is that something that would apply to a developing economy? As well as crafting such procedural rules as would permit timely consideration of not only the imposition of remedies. For example, are these remedies imposable by way of interim measures, as well as crafting procedural rules for receiving, evaluating, and deciding on the basis of voluntary undertakings or commitments. There's also value in developing agency capability in the negotiation, implementation, and monitoring of voluntary commitments, and offer professional development by way of training in the imposition and implementation of remedies, particularly structural remedies. And lastly, because our Philippine Competition Act supports the PCC working with sectoral regulators, it is worth exploring learnings from the experience of regulators, particularly those with a competition mandate, not only in the area of imposing remedies, but also in examining abuse of dominance in the regulated sector or market. And on that note, and with many thanks for your kind attention, I will close this very brief presentation.